the proposed regulations on the lottery weighing on the level of the wages is out. They did release it. It's going to be published tomorrow, every Tuesday from 5 p.m. Central Time to 6 p.m. We do bring in immigration updates from Houston, Texas. Along with me is my business partner, Emily and Stephen. Emily, what do we have today to discuss?
Yeah, today we're going to talk about that lottery process overhaul. So we knew it was coming for quite some time. We finally have the specifics of the regulation. It's just a proposal. And so we'll go through those specifics and when it might actually go into effect and all the good, bad, and ugly that comes with it. We'll also talk about a common situation that's happening right now. People who've already converted from H-1B to B2 after a job loss. They've been on B2 for 6 months and they're still working through the new job offer because things are taking longer now. Can you extend that B2 for another 6 months while you're waiting for that next job? We'll also talk about switching employers when you have a 485 that's been pending for 180 days. And lastly, this weird category called B1 in lieu of H1 or B1 in lieu of H3. Where does it come from? Is it actually used? And what can you do with it?
So first, this proposed regulation, Stephen. So it was been speculated from a long period of time. I mean, not long, I would say about 1 to 2 months. They've been releasing the information. Now, the proposed regulations, the draft of it, we already have it. Can you describe how it works in brief?
Yeah, so the proposal, and we'll talk about when it could go into effect in a minute, proposes a regulation that changes how the lottery is. So we take a step back. There used to not be an H-1B lottery, and then there was an H-1B lottery based off of a filing window in the first week. Then there was the lottery, the electronic registration process that we have now, where we register, March, and then they run the lottery. What this proposes to do in the electronic registration process is to give additional chances based off of wage levels. And so the Trump administration tried something similar in 2019. This is different than the 2019 version because what this will do is that if you are a level 4 wage that they're being sponsored for, you'll get 4 ping pong balls in the lottery. If you're a level 3 wage, 3 ping pong balls, level 2, 2, level 1, 1. And then they run the bachelor's cap and then whatever's left over, the master's cap. And so the idea would be, statistically, you could potentially, it would increase the level 4 having additional chances in the lottery, increase their chances of selection.
So, Emily, what Steven said is that if I were in level 4, I get 4 chances, 4 ping pong balls, and level 3, 3 ping pong balls, level 2, 2 ping pong balls, and level 1, 1 ping pong balls. So, statistically speaking, about the level 4 person has 4 times the chance of getting into the lottery system, though. Now, of course, and same thing, it will go down when it comes to level 1. Now, assuming that the $100,000 is another big thing that we're going to discuss later on. So if there is going to be $100,000 fees, though, it may change the entire scenario. Right now, let's assume that $100,000 is not there. We're going to discuss it. But of course, if the $100,000 is there, it's going to change the entire landscape of this complete H-1B application. So give your feedback with and without 100,000, how you expect the market conditions to go. And if I were a level 1 person, I'm an OPT and STEM extension, what do you expect? And if I were a level 2, and what if I am outside the country, what do you expect?
Yeah, so we have, 85,000 total visas based on the wage levels that have typically been filed in the past and received these 85,000 visas. With this new 4321 ping pong balls, we would expect, and this is estimated in the proposed regulations, that the number of visas that would go to level 1 wage petitions would decrease by about 10,000. Those 10,000 visas would be proportioned and go to the level 2, 3, and 4, to where level 2 petitions would have 2,000 more visas, more likely. Level 3 would get 4,000 more, and level 1 would get 3,000. I'm sorry, level 4 would get 3,000 more. So ultimately, I think people going into the lottery would see the writing on the wall, and that they're going to have better chances if they have a higher wage offer. So they're going to go for the companies that give them the higher wage offer, being the higher wage level. So we might see that very few people actually submit a registration for a level 1 wage. They might all just bump up to level 2 in order to try to get those higher chances, which kind of defeats the purpose of all of it. But in terms of this new distribution, if we have the $100,000, I think obviously if companies are offering a level 1 wage, they don't really have the extra $100,000 lying around to be able to sponsor someone from outside the US. So they're likely going to be looking only at candidates that are inside the US, which can increase the number of visas that are available to those that are in the US, which is a good thing. We want to promote people who've got that US master's degree. We already have that master's cap exemption that gives an extra 20,000 visas for that. So now I think even more of the master's cap people are likely to be getting more visas because they're in the US, they're on their F1, so they don't have to worry about the $100,000 fee based on how we're reading it. And they will likely be having those higher level wages as well.
Even now, if I were to come from outside the country, though, is this a proportion the same thing? Is it differ because I'm paying $100,000 more?
No, the two separate actions that are being done here. We have the $100,000 rule and maybe rule, who knows, and this proposed regulation. And again, it is a proposed regulation. There is a comment period. There will be an enactment period. I think based kind of on what we're guessing, if they fast track this, I think it could very much be in play for next year's lottery. I think that if it got slow played, if they have a lot of comments, they actually respond to them. You know, it might. There's a possibility that it isn't, but I think if we take it with kind of a grain of salt, you know, let's take litigation out, let's take delays out, that they can make this a final rule that's implemented for next year's lottery.
Anything else before I move to the next topic?
Yeah, so I think with that, it's going to increase the burden of the registration process. They've said that they're going to add more questions to the registration form. Right now, it's basically just very basic beneficiary information: name, passport number, country of birth, do you have a US master's or higher degree. Now, companies are going to have to state what the SOC code is for the job that they're going to offer, state what that wage level is, and the area of intended employment so that they can verify. So it's going to require basically almost doing an LCA prior to submitting the registration, which has not been required before. On top of that, they're adding more, I guess, guardrails for integrity, because they know that people might get the approval after they said they were going to get a level 4 wage. They get the approval in April, May, June, July, August, September. It doesn't take effect until October. What's stopping them from turning around and filing an amendment on October 1st, changing the wage level to a lower level wage? Well, they're saying that they are going to be keeping an eye out for that. And if they see that that's what the company is doing, they will go back and deny the amendment and revoke the original approval. Same thing if they see companies coordinating together to, hey, I'll do the lottery, I'll say that I'm going to pay this level 4 wage. And then on October 1st, this company over here that I'm friends with is going to file an H-1B transfer for the actual job at the actual lower wage. They're going to be keeping an eye out on that to make sure companies aren't colluding with each other to get around this wage. But that's going to just add, how are they going to enforce that? That means more site visits, more RFEs, more notice of intent to deny. Things are going to take longer. So it's just kind of creating more hassle and burden rather than alleviating it, unfortunately.
Even I have a job offer with a company that I probably don't want to join, but our package is very good. It's level 4 salary. But there is another thing where I want to join this artificial intelligence with a startup company, which have a very high prospects. Now, of course, Stephen, in the 2025 lottery and 2023-24, what we have seen is that in the lottery system, now, even if you have applied for multiple companies, only one person, only one Rahul Reddy will be there. But if I have 2 job offers and I really want to join level 2 job, and I have an offer with another big company with level 4, how does that going to work?
Yeah, they make it clear that you'll get the lower the benefit of the lower wage level. So you'll get 2 ping pong balls because you have a level 2 and a level 4.
Let's move them.
So yeah, real quick, I mean, just dovetail this one or put a bow on it. Proposed rule. Comments will be available. Get your comments in. I anticipate litigation on this one because surprise, surprise, it's something weird in immigration. It might be good policy. That's, I don't, my job's to follow the law, but I think there's some uphill battles with what the text of the Immigration Nationality Act says. And so, we'll see. We'll see what this actually ends up. So stay tuned.
And I'll go to the next topic, is the B2. We have seen a lot of people who lost the job and on H-1B, and they did move on to B2, which allows, especially USCIS in their website said that if you lose the job, you can move on to B2 and convert back into H-1B. Even though the B2 has been pending, they've been approving the H-1B approvals, and people have filed a B2 application online, which is very convenient for them to file it. Now it has come to a situation for some of the people, B2 allows only for people to stay up to 6 months in United States. Now, after 6 months, if they don't have a job, should they go back? Well, one thing is if they go back and apply the H-1B visa, we don't know if the $100,000 is applicable because your new petition will be filed after September 21. It's a little bit vague at this point of time. There's no clearance at this point of time if the $100,000 is applicable. Some maybe not, we don't know. But it may be worth for you. You can file an extension of the B2. There are people who have filed B2 extension, got their B2 extensions approved, and they have explained it very clearly that they're going to stay, they're not working, they're not violating any status in United States, and they're probably maybe looking for a job too. There's nothing wrong in it. You can file a B2 extension. If by any chance the B2 extension is denied, you can leave within a span of 10 days. You can leave the country. Not much damage is done. So we strongly recommend people you can move on to B2 extension if you want to stay in the country and look for a job. Nothing wrong with it. Any difference of opinion, Emily?
Yeah, I agree with that. And definitely we've done it and seen approvals. I would say you're more likely to get a request for evidence on the B2 extension asking for more information about the purpose of your stay, as well as proof that you have a residence abroad and that you're only going to be staying temporarily, all of that non-immigrant intent issue. But once we provide the evidence, I've seen approvals. So I do think that it's a viable option still if you're just waiting on that job offer to come through.
And how about Stephen? If I go back, I have an H-1B and I don't want to stay here. I will go to India and look for a job. Is 100,000 applicable for me?
Yeah, it's a good question. Potentially, yes. Again, we have a little bit of gray area on this. We have a ton of questions on our chat. We know it doesn't apply to things within the US. Changes of status in the US it shouldn't apply to, but for sure transfers, extensions, amendments in the US it shouldn't apply. I think it would apply if you go outside the US and get a new H-1B. But there's some, because they didn't use terms of art that are common in the INA, there's a gray area. I would expect to have to pay it, yes. And if they decide you don't, great. I don't think I've ever heard anybody be upset that they don't have to pay $100,000. But yeah, I would anticipate having to pay for it.
Emily and Stephen, if I have the presidential proclamation and then we have the USCIS information that they did fact sheet that they released in CBP, and these Twitters, what should I believe? And the press statements.
I think the one thing you can believe is that if you are in the US, it should not apply to you right now.
Yeah, I think
That's it.
I think in the coming weeks, we're gonna get a lot of guidance that I hopefully is in one direction and not all over the place. I know somebody asked about litigation. There is litigation being filed, I think, this week on that. So I think we're going to get more clarity in the coming weeks. And so I know, I know we all hate telling people don't travel unless you absolutely need to, but like if you have an approved petition or a filed petition that was filed before Sunday, you're good, right? Well, they've made that clear too, that if you're in the US or even outside the US and your petition was filed before Sunday, this does not apply to you. Okay. What we don't know is if we file something today and you have to travel in December. We don't really know. I don't think it will. I don't think it will in that situation, but we don't know for sure. So just hang tight for more guidance on this, unfortunately.
Coming to the topic of the people who file the adjustment of status, and it's pending, and assuming that I-140 is approved, though, guys, can you change the job 180 days after you file the adjustment of status? The simple answer is yes, you can. The new job has to be in a similar profession. People ask me this question, that the job has to be same. No, the job doesn't have to be exactly same. I mean, I've been corrected on this, but I'm going to quote it again. What I said to some people, only robots do the same job again and again in the same way. However, one of the robotics engineers said, no, Rahul, you are wrong. They don't. They improve. They do differently. They improve. Okay. I take back. Even robots don't do the same job again and again. I am sorry for that statement. So yes, you are not a robot. You don't go to the same job. It has to be in a similar profession. And let's say, for example, if you are doing a Java software and then you move to SAP, according to us, it's still in the software field. Nothing wrong with it just because you move into SAP. However, can you actually move from Java software to Java coffee beans making? Because most of the people we know that I particularly drink is Java coffee. Sorry, even though they sound the same thing, Java software and Java coffee, the spelling is the same, but no, you can't do that thing. The spelling doesn't make much difference. It's a job duties are not software profession. Java coffee making is not Java software. You can't. But if you move from Java software to SAP, we don't see any problem in it. And it's
I
very
think the
easy. Go ahead.
Oh, go ahead, Rahul.
And do you need to file an I-485J supplement? We generally don't recommend people to file an I-485J supplement. It's not needed when you change the job. If there is an RFP or if there is an interview, you definitely need to provide I-485J with a new job. Sorry, Steven, go ahead.
Yeah, I think the one way I tend to describe this to clients is, every SOC code, and I've got outside activities that I do for work that I have an SOC code that they've assigned because it's a lawyer, right? And we start off with that first 2-digit number, 15, 11, 13, whatever. I think, the way I see it is that generally speaking, and not always, because there's some weird subsets, but generally speaking, if you're in that same SOC code family, it's pretty similar.
You
Not
said
always.
SOC code or SOC family?
Oh, the family, right? So the 15 dash whatever are computer positions, right? Now, obviously, I don't, there might be some that are very unique positions, but for the most part, I think it's a good way to look at it. And then if it's not, then, take a look.
Yeah,
Okay,
and I'll add that, people always ask, what about career progression? What if I have, was sponsored 10, 15 years ago as a software engineer, and now I moved up to be like the VP of engineering for my company? Is that going to be a problem? No, it is not. Thankfully, in the guidance in the policy manual, CIS has clearly stated that they get that career progression occurs over time, and that they do take that into consideration. If it's part of your normal career progression to move up from software engineer to senior to lead to team lead to VP, that is still considered to be in the similar occupation and qualifies.
tough questions coming to you, Emily and Stephen. Now, this B1 in lieu of H-1B, and Stephen said last week that it's 2 weeks ago or 10 days ago when you're not there, Emily, that is according to the Foreign Affairs Manual, it's allowed. And these are the 400 or 500 South Koreans. Most of those people got arrested because they were working on B1 in lieu of H-1B. And they work on B1, B2 in lieu of H-1B? What are the rules and why, if Stephen is telling they can work, and why did they got arrested?
Yeah, I mean, it is definitely there in the Foreign Affairs Manual. It's still there. It is considered to be a business activity if you would otherwise qualify for an H1 or an H3, because you can use it for training as well, but you're not actually entering the US labor market, and it would be inconvenient for you to go through the whole process of getting an H1B through the lottery and all of that, or getting an H3 for training when you're only expected to be in the US for a very short period of time. This can be an option. There are specific requirements for it. You have to be employed by a foreign company. You have to remain on that foreign company's payroll. All salary, remuneration, compensation has to only come from that foreign source. The US source can only provide like an expense allowance or reimbursement. And the payroll has to be dispersed from abroad. If all of those are met and we're coming for temporary purposes, those are considered to be business activities. They should have a B1 in lieu of H1 notation on their visa stamp in order to make that clear. There was some plans back in 2020 to actually eliminate it. There was a proposed regulation from the Department of State, because it's not actually in the regulations, it's not in the statute. It's just kind of the interpretation of the State Department of what permissible business activities are based on the case law. There was actually a big settlement in 2013 with Infosys where they were alleged to have used this program incorrectly by actually having people coming to the US and entering the US labor market and doing work that US citizens would normally be doing. That ended up being a $34 million settlement, but that was 10 years ago, 12 years ago, and we do still have this visa category. I think the difficulty is, when it's a very fine line of what is considered work versus what is considered business. And with this case of the Korean employees, they had likely told the consulate this is what they're doing. They told CBP this is what they're doing. Consulate approved the visa, CBP gave them an I-94, and then ICE comes in just, I'm assuming based off of a tip, and sees all these people with different that don't look like Americans doing all of this work. And so they just go in guns blazing as is their new method. But it is
Yeah,
still an option.
there's a number of quasi work related B visa exceptions in the Foreign Affairs Manual, but I did one a few weeks ago for some European welders that were coming in to go to the outer continental shelf, and I kind of learned all about that. They were going to do this welding project on some offshore oil rigs, and they've got special technology. And there's not another visa category that fits that, by the way. These are heavily scrutinized by Department of State. It's not, you get a B visa, there's some scrutiny, right? There's a level of scrutiny to get a B visa in general, like even if you're coming to Disney World, right? But the B in lieu of H1 annotation, I mean, that's coveted and held close by the consular officers to ensure it meets all the criteria. And so it's not a very easy thing to get for sure, but it is an option. And if you qualify and you can get it, it allows you to do these certain activities for short periods of time in these certain circumstances.
We'll go to the questions. There are a lot of questions coming on with regards to the $100,000 thing. There are certain things that are yes, there are certain things that are no, there are certain things that are gray. I'm going to tell you, if you have an H-1B, you are in United States, you are filing for an extension in United States, this $100,000 is not applicable at all. If you are in United States, if you are on OPT and STEM extension, or if you are on H4 or L1, and you are going to get into the new quota, you're going to change the status to H-1B, this $100,000 is not applicable. If you are here in United States, converted from H1 to B2, and right now your B2 is pending or B2 is approved, and you want to apply for change of status from B2 to H1B, because you had a H-1B before, you are not subject to the 100,000. If you're going to apply under the new quota, is somewhere in March of 2026 it starts, and you are outside the country, you are in India, you are in Africa, you are in Australia, you're applying in the new quota, you are subject to the $100,000 fees at this point of time. Now, there are some things which are gray area, which is if you are outside the country, but you had a H-1B before, and you are applying for another H-1B right now because you have been counted to the H-1B before, we are not yet sure whether this $100,000 is applicable.
Question that we keep getting, anything on the exemption for physicians or litigation? So one, no on either. The litigation, it's being worked on, being finalized. I do expect something to be filed this week by various groups. The physician exemption is something that I think yesterday was a story that came out that said a White House source says that doctors are going to be exempt. We have not had anything officially written that says that. So I do expect it, to be honest with you. I think of all the things that sometimes we trip over our own 2 feet with immigration, making it harder for highly skilled doctors would be one of the most tripping over our feet. So I expect it, but we'll see.
Ashwari has a question with this $100,000 fee. Would it be applicable to someone who already has an NIW I-140 petition approved? Since the executive order is talking about exemptions for being in the national interest, I-140 petition is national interest waiver. Unfortunately, I don't think that automatically means you would qualify for the exemption, because a national interest waiver has certain requirements set by statute and regulation. And this exemption is going to have its own completely different requirements, which we don't know what they are yet. So would you be able to submit your NIW I-140 approval as proof that your work is in the national interest and you qualify for an exemption? I doubt it. Maybe it could be one factor, but I don't think that would be the only thing they're going to look at.
What if my position, I can move from level 1 to level 4 within the company? And of course, if I'm going to be working in San Francisco, the level 4 is way high. But if I'm going to be working in Kansas in a remote place, the level 4 may be way lower. Can I work from Kansas and file in level 4? Because even though I'm not getting that much paid, and will I get 4 ping pong balls if I were to do that?
Potentially, I think it would depend on what the ultimate plan is for when the H-1B actually takes effect and when the petition is actually filed. So let's say the intention is for you to actually move to Kansas and you are being offered the level 4 wage in Kansas. Your employer submits a registration saying it's a level 4 wage. You get selected because you put your name in the bucket 4 times. Now, when you go to file that petition, the company can't now say, we're going to move this person to San Francisco and pay the level 2 wage, which is the exact same amount as the level 4 wage was in Kansas. That won't work. You have to match what was on the registration with your actual petition filing and then actually follow through with it. And so you'd have to stay and work in Kansas. But if that's the ultimate plan, yes, you could do that.
Even if a university is filing an H-1B right now, if somebody wants to change the status within the United States, they don't come under the cap right now. So they don't go through the $100,000 because they're changing the status in United States. Everybody knows that the universities and nonprofit higher education institutions don't come under the cap. They can file the H-1B right now. What about if they are filing for a doctorate guy and they want to bring him as a professor right now, and this gentleman is outside the country? Is this $100,000 applicable?
Yeah, I think that's the group that is most immediately impacted by this proclamation are cap exempt employers who are looking to hire someone. Perfect example. I was talking with a colleague of mine, does some work for his local college, and he says they do some hiring right about now of professors to start in January, right? That they're going through their immigration paperwork. They're abroad because they're internationally, working at international universities. They would be subject to it. And would, a smaller school necessarily do that? I don't know. That is going to be interesting as we impact higher education with this. Real quick, just because I've got to hop off, go coach a little second grade football here. Just stay tuned. We're gonna get more information in the next few days. I think next week, and I think we've shown that we will go live with something as soon as we get actionable information on this $100,000 thing.
Emily, can you file a labor certification and I-140 on when you're an H4? Can you file a labor and I-140? And if I were a H-1B, I moved to H4, I'm an H4 EAD. Can you file a labor and I-140? And once the I-140 is approved, can I move back to H-1B?
Yeah, absolutely. There's no requirement that you be in H-1B or any particular status in order to be sponsored for the green card, and can go through the labor certification and I-140 while you're on H-4.
Bhaskar is asking this question. If the H-1B has been already approved, it was filed way before September 21st. However, the gentleman has not gone to the visa stamping. Is this $100,000 applicable to him? No, because the petition was filed before September 21st of 2025. So this this $100,000 is not applicable. It's only applicable to the people who are outside the country, and when the petition is filed after September 21st. Since this gentleman H1 was filed before September 21st, he is not subject to $100,000.
Yep, same thing for Sumit. He says, does the proclamation impact already filed H-1B petition, change of status from F1 to H1, but still not approved? So that would be from this past year's lottery. No, it does not. It's very clear that it only impacts H-1Bs filed after September 21st and only impacts individuals who are outside the US. Krishna says, I have an EB2 priority date with a May 2014 priority date, and I'm planning to downgrade to EB3 using the dates for filing. Is there a deadline to downgrade, and is it October 31st? No, not necessarily. It's as long as the visa bulletin doesn't move backwards or they don't stop using the filing date chart the next month. So as of now, technically, yeah, you want to make sure it's filed before October 31st, but usually before the end of the month, we will get next month's visa bulletin, and that will tell you if you can now file all the way into the end of November. Chunduri says, if I transfer my H-1B from company A to company B, I'm assuming this is after September 21st, does this count as a new petition? And if I travel outside the US and return, will I be required to pay the $100,000 fee? So it does not count as a new petition. I think what they mean by new petition is checking the box for new employment as the basis for classification on the I-129 form. For a transfer, you check the box that says change of employer because you're already in H-1B status. It also wouldn't apply to you because you're in the US. If you're filing a transfer, it's because you're in the US. The big question is, if you then travel afterwards, will you be required to pay it? And that's what we don't know yet.
Very interesting question from PR3 watchers. How is the wage level calculated for H-1B selection, especially for the people who work from home? It depends on how the employer documents it. Typically, the employer could document that you will be working from home and you will be working from the office location also. So whichever is the higher, though, that is where we're going to calculate the wage level. Let's say if your company is in San Francisco and you're working in Kansas in a remote place, and the wage level will be calculated based on the San Francisco, though. However, if you're working in Kansas and they do not say that you will not go to the company premises, I mean, not that you can occasionally visit, not that you'll not go there to San Francisco and work. In that case, though, it will be only Kansas location that the wage level will be calculated, not San Francisco. So depends on the documentation. If the document only your home, it will be the home location. If the document home plus work, whichever is higher, you will have to choose that one.
Deepti says, if I already had an H-1B approval previously with an approved I-140, but then changed to H-4 EAD, now if I have to change back to H-1B, does it count as a new petition for this $100,000 fee? I don't think it does, although on the basis for classification for that kind of application, you do check new employment. You're filing a change of status because you're inside the US. I think the overarching thing to remember is that this is a travel ban. It's an entry ban. 212F only allows the president to stop people from entering the US. If you're already here, he can't do anything to require you to pay this extra fee because you're not traveling. So as long as you don't travel, it should not apply to you. I have a feeling, I think, that this is intended when they say new petitions, they're talking about new cap subject petitions or petitions for people who are exempt from the cap based on their employer, not needing to go through the lottery. I don't think they're intending this to count for all the other types of H-1Bs out there. That's my guess, but I don't know why they announced it now, considering that that doesn't happen until next March.
A lot of people are asking this question again and again, guys. If you are changing the status in United States from H4 or OPT or L1 to H-1B within United States, it is not applicable. $100,000 is not applicable. It's very clear they said it right now.
Diti says, what is Project Firewall initiated by USCIS? I think you mean initiated by Department of Labor. It is basically the Labor Department reiterating that they have the power to enforce LCA violations, wage and hour violations, and they're looking into it more carefully, and they are planning to review things more thoroughly and use their authority more. They've always had this authority. Nothing has changed with that. I think they're just looking more at compliance for companies that file LCAs, which are for H-1Bs.
I'm planning to go to India and return back on L1. That may be worth. I mean, if you're going to return back on L1A, though, definitely the $100,000 may not be applicable. Is not applicable for you. Only if you're trying to come back on H-1B, that may be applicable. May be applicable. However, though, when you are Sadanand, when you are trying to go outside the country, though, it's better to calculate all the pros and cons. It's not that easy to get an L1A to come back into United States. You need to evaluate yourself, what kind of position you're going to be hiring. Is a company qualified for it? Is the position that you are going to do in India is going to be qualified for it? Is the position that you're going to be doing in US is going to be qualified for it? The other intention that you also have definitely is the EB1C. I can sense it. And you also need to look into if your position there in India and the position here in United States, when you come back, is that qualified to be for the EB1C? You need to do all those things before you make a big move outside the country.
A lot of questions again about the $100,000. Is a transfer a new petition? No, because a transfer, you're in the United States. Is a change of status a new petition? No, if you're in the US, you're filing a change of status, an entry ban would not apply to you. Same thing for an amendment plus extension. Anything you're filing when you're in the US, it should not impact you. What we don't know is if you file something after September 21st and then you travel, will you need to pay it in order to get back? That's what we don't know yet.
I have my I-140 approved. I have this I-140 approved, and in July, I have not received the I-140 approval. Is there any way I can get this I-140 approval? You can, if the employer is not giving you the I-140 approval or it's not been received, employer can contact, but just in case employer is not giving you, you can file a freedom of information. You can just Google FOIA USCIS, and you can fill out that form. It takes 10 minutes for you to fill out, and they will take about 5 to 6 weeks to give that I-140 petition. Even though the I-140 approval is not in there, though, you practically can use that for any purposes you need it. It will act as an I-140 approval.
Angel says, can we cross the Mexico land border with an expired H-1B visa stamp and a valid I-797 in the current situation? Assuming that your petition was filed before September 21st, yes, no issues with that at all. Automatic revalidation is fine. What we don't know is for people who have filed a petition after September 21st and then travel planning to use automatic revalidation, will they be expected to pay this $100,000 fee? We don't know yet. Mr. Z says, are H-1B extensions within the US impacted and any benefits of applying in premium processing for an extension? So no, they're not impacted because you're inside the US. It does not apply to you. But yes, there are benefits of applying in premium processing for an extension. The biggest one is you get the decision before your current status expires, because if a decision is a denial and your current status has not yet expired, you have time to potentially refile or file a change of status or file a transfer. There's so many more options, and you can stay in the US while you're doing that, versus if you file an extension, it takes forever to process. You're previous status expires and then you get a denial, that denial puts you out of status immediately and you start accruing unlawful presence immediately. It's very difficult to get back into status without leaving the US in that situation. And with this $100,000 fee, that becomes even more of a problem, because if you have to leave, and then in order to come back, your company has to file a new H-1B petition, consular processing to get you back into status, that's when that $100,000 fee could kick in.
Emily, there's an interesting question Prince Stanley has brought up. With this $100,000 fees, can you expect a movement of the EB2 and EB3? I'm going to speak and I will want you to correct me, and I also want your comment on that, though.
I don't think
I
so.
Well, I may differ a little bit from you, though. Okay, why you don't think so? That
Well,
what
I
the
mean,
question what the
the
question asked by Prince Stanley is the priority date expected to move for EB2 to AB3? And Emily says she doesn't think so. Go ahead.
Yeah, I don't think it will move much, because we still have to get back to where we were in October 2020. There are thousands of people already pending that are going to use up all of the visas that became available this year and the next year and the year after that. And having this $100,000 fee, again, it seems like it's only going to apply to new petitions in next year's lottery, which are people that do not have a priority date yet. So someone with a 2026 priority date who now isn't going to get the visa and therefore won't get a 2026 priority date isn't going to impact anybody that has a priority date earlier than 2025. Now, if this $100,000 fee starts getting applied to extensions and things like that, we might have a different story if people leave and decide not to move forward with the green card because they can't keep the H-1B status. But I don't think that's what's happening here.
I may differ with you a little bit, Emily, on this. I think so that the priority date may move forward in the couple of years, may not be immediately, though. One reason is that the rest of the world people may not be that many, because this $100,000 is applicable not just for Indian nationals and Chinese nationals, it's also applicable for the rest of the world too. If the rest of the world, this $100,000 is applied to, there may not be enough number of H-1B applicants. Thus, there may not be number of people who will be applying the green card. So when the rest of the world don't use it, as Indians are only allocated up to 10,000 of the 140,000, if the rest of the world don't use it, the Indians may get a bulk of those green cards for Indian nationals, and things may be cleared soon. And as Emily pointed out, that if the people are going to go outside to get the stamping and they are going to apply the $100,000, and we said very clearly that, yes, we may see some changes because some of the people will go out and get stuck outside the country because nobody's going to pay, people are not going to pay $100,000 fees. It's just like there are people who are standing before in the line, and if they go outside the country to get the stamping and they don't come back, your line will be advanced. So it's like another one bite the dust and you get a chance to get it, is my feeling, Emily. But I've been wrong more than you in predicting the priority dates. I challenge you on that.
Simple Talk says, what could be the trend for PhD graduates with this new weighted policy? Will the probability increase or decrease? Completely depends on the job offer that you get as a PhD graduate. If you have a PhD and you're getting a level 4 wage because your PhD allows you to do very high level work, then you would get 4 times the chances. But if you are a PhD doing research, entry level stuff where you're only getting a level 1 wage, then you only get 1 chance. So the PhD doesn't really come into play at all, other than if it's a US degree, to where you would get the extra chance in the advanced degree master's cap.
Jendra Kumar has this question. His parents have stayed for 7 months and 15 days on a B2 visa, I'm assuming. And when they're trying to come back after 6 months after they went outside the country, their visa has been canceled and they were not allowed to come in Abu Dhabi airport. That is right. That's going to happen. Here is the rule, though. If you are staying 1 day over your period of authorized stay, so for example, if the parents have 10-year multiple entry visa, when they enter into the country, can they stay for 10 years on a visiting visa? Absolutely not. They can only stay for 6 months. And if they stay one day over the 6 months, their visa is considered to be canceled. It's no longer valid. If they stay one day over it, they have to go outside the country, which is to their home country right now, and they have to get the visa stamping again to come back into the United States. Since your parents didn't went and got the stamping again because they stayed 45 days over and above the 6 months allowed, their visa is automatically canceled. And when they're trying to re-enter into the country, that's the reason they have been denied entry in Abu Dhabi. Lucky that these people were being denied in Abu Dhabi. If they would have been come all the way to the United States, sometimes they put them in the detention for 1 or 2 days and put them in the next flight back into their home country. That would have been more terrible, though. So definitely for anybody who has overstayed, their visa is canceled. Be very careful on those things, guys.
Anonymous says, with the impending gold card applicants joining the EB1 and EB2 queues, will there be any changes expected to address the existing backlog, and how will this impact EB3? I really don't see a lot of people taking this gold card seriously, especially now that they confirm that all you're doing is getting into EB1 or EB2. Particularly EB2, if you're from a backlogged country, you're literally getting nothing for paying $1 million. There's nothing guaranteeing that you're going to actually get the green card. You could pay your $1 million and then be denied. So I don't know how many people are actually going to use it if, in fact, it actually comes forward.
Emily, one other serious discussion that I want to discuss about what has been raised by Mahi. If the $100,000 is applicable to the people who are outside the country, there will not be enough demand. Could the people in United States be lucky enough to get all of these H-1Bs? Even if there is some demand, the demand will be very, very significantly lower, which you agree. Because especially if somebody has to pay $100,000, the demand will be way, way lower. Everybody agrees on that one. Is this a big boon for the people who are on H4, L1 wanting to move H-1B, and especially OPT and STEM extension who have been trying to hit the lottery for so many years and couldn't get it?
Yeah, I do think so. And I think that's part of why, assuming Trump can be believed, when he said that he talked to all the software companies in the US and they were all very happy with this, because now they're going to get their pick of more applicants, and their applicants actually have a better chance of making it through the lottery because they're more likely to be sponsoring people who are inside the US. So yeah, I do think if we cut out all of the consular processing petitions, which is almost half generally, everyone will have better chances. I think we'll still get more than 85,000 registrations with all the people that are in the US, but yeah, it should improve people's chances.
And Emily, if that is the case, though, then there may be, even if I'm at level 1, I may get opportunity, because if there are no applicants, then I should be getting it. Is that right? I mean, or will they? The lottery is typically like within that period of time, 20 days, there is a lottery. Will they extend it? Like, for example, instead of 20 days, they will put more until October, whatever it is.
I think that, yeah, it does increase the chance that even a level 1 wage will be selected, which is one of the better things about this current proposal compared to the previous proposal, because the previous proposal would have given the visas out in order of wage level. So level 1 would have never gotten any. Now level 1 still has the opportunity. It's just a fourth of the opportunity of a level 4, for example. But yeah, if we have so many fewer registrations that are not using up the level 2, 3, 4, level 1 could get picked too. You could, I mean, conceivably, you could end up with all level 1 wage people selected based on my understanding of probability and math from years
Yeah,
and years ago.
if this doesn't get stuck down in the courts, though, definitely This is a ballet dance time for the people who are an F1 OPT STEM extension, H4 guys, L1 guys wanting to jump into the H-1B. It's probably celebration time. Maybe you should thank Trump, though. I'm not a fan of Trump, but you can be.
Shan says, is USCIS already following this $100,000 rule, since obviously it took effect already for petitions filed after September 21st? I can confirm that attorneys were filing cases online today, and there is no option for the $100,000 fee to be paid. Even if you select all of the boxes to show that this person is cap exempt and outside the US, there's no option for the $100,000 fee to be paid as of today.
Some questions with regards to some favorable immigration laws the Congress is going to pass. Absolutely not. We are not expecting any favorable bills coming in right now. People are asking, why don't we ask Trump administration to do some favor of not counting the family members and certain other things? This is not the right time. This administration is not going to do it. So I don't want to put efforts on those things, though.
Raja says, has any H-1B transfer petition been filed by our firm this week? I'm filing transfers, extensions, just as I normally would. So they're for people inside the US. So I'm assuming that this $100,000 fee doesn't apply. And so it's business as usual for my cases.
I have my H-1B visa expired. I have an advance parole. He filed an adjustment of status, which is still valid. Do you see any problem in me traveling outside the country and coming back? Absolutely, I don't see any problem at all whatsoever at all. We haven't had any problem with advance parole people traveling outside the country. Even though your visa is expired, we do not see any problem whatsoever at all. And now you all know, guys, that I'm not a fan of traveling outside the country. But when it comes to the advance parole, we have not seen any problem whatsoever at all. Anybody who's traveling outside the country on advance parole, never a problem.
Jatendra says, is EB1 and EB2 closed now? I'm assuming this is based on the gold card announcement, or can people still apply? So there was supposedly a comment from Commerce Secretary Lutnick stating that they're going to be suspending regular EB1 and EB2 in order to get this gold card up and running. What does he mean by that? Well, number one, can't trust anything this guy says. If you look at what happened on Friday, he was completely wrong about this entire $100,000 fee and got everybody all worried and scared for nothing. So he probably has no idea what he's talking about. If anything, the only thing I can think of, because he used the word suspend, if we can believe what he's saying, is what if they're planning an immigrant visa travel ban, which they also did before under the previous Trump administration. Again, 212F is entry ban, travel ban. It never impacts anyone inside the US. Most employment base is filing for adjustment of status. They're inside the US. So that would not be impacted if they were to attempt something like that. I'm not saying that they are. I'm just trying to read in between the lines of what this guy is saying, even though he's been clearly wrong, so clearly wrong before. So I don't think there's a big chance of there being a problem with EB1 and EB2 going forward.
Will all the $100,000 and other things, is it going to benefit the computer science majors that are US citizens and your US workers? I don't think so. One of the main reason is that right now, a lot of companies are trying to look into this way. If we can't get the people properly in United States, why can't we move our business somewhere else? When we move the business somewhere else, probably if you're a US citizen, the best way to is that retool yourself to get an immigrant visa to go to India. That's where most of the companies may be moving if more restrictions are going to come. If you look into in the past 2-3 years, though, the majority of the GDP growth that came in from technology sector, though, which NVIDIA and certain other kinds of companies, technology companies, have fueled in, and that has done a very good job. And you are going to move those companies outside the country, the jobs are going to move. It's like moving the manufacturing companies to somewhere else is not good for the United States. Same thing, moving the technology companies outside the country is not good. If you have more technology companies doing research, doing work, doing innovation here, then more jobs will be created in USA for the computer science workers and the US citizen. That's my belief. And if you try to push too much of them, they will try to go outside the country and try to do the same thing. And then maybe the US citizens might want to tool themselves to computer science guys to move outside the country and work outside the country, though, because jobs are going to move if the way things are turning right now.
Number 44 on X says, I only received the I-79C approval notice without the I-94 attached to it for an H-4 extension. Is this normal, or do I need the I-797A to stay in the US? It sounds like you may have just received the courtesy copy. If you worked with an attorney, it's very likely that the original approval that has the I-94 attached went to the attorney's office, and they should be forwarding that original to you, because you do need that. That has your I-94 on it. It becomes your new I-94. The I-797C without the I-94 is not actually your approval notice.
A question from Amulya, is it a risk for folks already in USA with approved H-1B? What does the future look like? Right now, as long as you don't plan to leave the country, stay in the country and work in the United States, it looks fine. But the only thing is that if the H-1B's extension are being filed after April 21st, after September 21st of 2025, and then you planning to go outside the country to get the stamping, definitely is a problem. And from the beginning, though, if you have watched our YouTube videos before, we have been beginning saying that don't go for stamping because this administration is not good. So as long as you're in United States, we don't see any problem. But if you leave, it's going to be a potential problem. Anything else, Emily?
Well, I guess we're out of time. Thanks everyone for joining us. As usual, we'll keep you up to date with all the latest and all the twists and turns of the Trump administration. So definitely stay tuned to our YouTube channel and our social media as well.
Thank you very much for tuning.